What is a back-to-back transaction? Why it arises and why it is so commonly misunderstood. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Let's begin with the basic point, because this is one of those aircraft transaction terms that sounds informal but carries serious legal consequences. A back-to-back transaction is not one sale. It is at least two separate sales, usually closed in sequence or simultaneously, in which an intermediary acquires the aircraft from one party and then resells it to the ultimate buyer. NBAA's back-to-back transaction primer describes the structure in essentially those terms. The intermediary, often a broker, dealer, or a market participant, buys from the seller and sells to the end buyer. Aviation International News, through the National Aircraft Finance Association, similarly explains that these structures can involve one or more intermediaries and sometimes multiple links in the chain. So the first lesson is simple and memorable. If there are two contracts, two prices, and two transfers of title, you do not have a colorful variation of a normal deal. You have a different legal animal. Why does it arise? In large turbine aircraft, it arises for practical reasons. Inventory is thin. Buyers want access to off-market airplanes. Sellers may want a fast, certain number without negotiating every downstream issue. Intermediaries may have relationships, market intelligence, import capability, refurbishment capability, or a willingness to take price risk for a spread. Sometimes the intermediary is solving a timing problem. Sometimes it is solving a confidentiality problem. Sometimes it is solving a tax, registration, or repositioning problem. And sometimes it is simply monetizing information asymmetry. That is why these transactions are common enough in today's business aircraft market to be familiar to sophisticated brokers, title companies, escrow agents, and transaction counsel. Even if NBAA correctly notes that they are not historically the standard structure and have become more prevalent more recently. In other words, they are not exotic anymore, but they are still dangerous when they are treated casually. Large turbine aircraft make the danger more severe. The dollars are larger. The due diligence burden is heavier. Engine programs, maintenance tracking, damage history, interior completion, supplemental type certificates, enrollment status, export issues, financial conditions, and registration timing all matter more. A Gulfstream, Global, Falcon, Challenger, or large cabin Embraer is not a commodity widget. Every one of those aircraft carries a document history, a maintenance story, and often a tax and financing story. So when an intermediary steps into the chain, it is not merely stepping in between two parties. It is stepping between two compliance narratives. Here is something I'd like you to take away from this. And remember, in a large turbine aircraft back-to-back transaction, the spread is earned in the gap, but the liability also lives in that gap. The next thing people misunderstand is that the intermediary is not automatically doing anything improper. A true dealer or trader can lawfully buy and then lawfully resell. The law does not prohibit profit. What creates risk is incomplete authority or a structure that is represented one way but functions a different way. If the intermediary never truly controls the contractual chain, cannot deliver the aircraft, lacks the ability to pass marketable title, or is hiding critical facts about condition, ownership, or price mechanics, the deal moves from efficient to unstable very quickly. Federal law explains why. Under 49 U.S.C. Section 44107, the FAA maintains a recording system for conveyances affecting interest in civil aircraft. Under Section 44108, the validity of those conveyances against third party turns on recording rules. And the FAA registration application instructions make the practical point unmistakable. If the buyer is not purchasing from the last registered owner, the buyer must submit conveyances completing the chain of ownership from the last registered owner to the applicant. That means that the aircraft registry is not interested in the commercial story. It is interested in the documentary chain. That is why I tell clients this: a back-to-back structure is only as strong as the weakest paper in the chain. In a large turbine setting, that paper weakness can hide in several places. It can hide in the first purchase agreement, where the intermediary has weak assignment or closing rights. It can hide in the second agreement, where the end buyer is promised delivery standards that the intermediary cannot force the seller to satisfy. It can hide in the escrow instructions, where funds are timed incorrectly. It can hide in the title package, where releases, trust documents, or registry filings do not line up. And it can hide in the records room, where intermediary promises access it does not actually control. That is why good back-to-back starts with one blunt question: who can actually cause what to happen and when? If the answer is vague, the deal is already telling you where the dispute will come from. And in the large turbine world, those disputes are rarely small. They involve 7 or 8 figure assets, inspection findings, maintenance reserves, engine exposure, and reputational damage in a very concentrated market. In short, the first thing to understand about back-to-back transactions is that they arise because they solve real market problems. They are not rare curiosities, but their legality and prudence depend on disciplined, structured, real authority, and a documentary chain that can survive scrutiny. I'd like you to take this away and remember this. In large turbine aircraft transactions, a back-to-back deal is not risky because there are 2 closings. It is risky because there are 2 chances for reality and paperwork to diverge. Where back-to-back deals break down: title, records, escrow, and risk allocation. Now let's turn to the second layer of the analysis, where these transactions actually go wrong in the real world. And the answer is not usually the concept. The answer is execution. The first failure point is title and chain integrity. The FAA recording rules in Part 49 and the registration instructions for Form 8050-1 make clear that if the aircraft is not purchased from the last registered owner, the conveyance chain must be complete from that owner to the applicant. This sounds ministerial. It is not. In a back-to-back transaction, there may be a first bill of sale, a second bill of sale, trust paperwork, payoff letters, lien releases, escrow instructions, and in some cases, international registry or financing files that must align by time, by party name, and by serial number description. If one of these links is wrong, The buyer may have paid for an aircraft that cannot clearly and cleanly be registered or financed on schedule. Remember this: on closing day, speed does not cure a broken chain. The second failure point is the mismatch between the first contract and the second contract. This is where intermediaries get hurt and where buyers often do not realize how exposed they are. If the intermediary agrees to deliver the aircraft to the buyer with fresh inspection status, complete records, certain cosmetic conditions, specific maintenance program enrollment, or a hard closing date, but the intermediary does not secure those same rights against the seller, then the intermediary is selling certainty it does not own or possess. In a piston deal, that can be painful. In a large turbine deal, it can be catastrophic. A large turbine aircraft is often sold with pressure from financing, management commitments, crew planning, tax planning, and charter schedules. If an unexpected discrepancy appears during the pre-purchase inspection, corrosion, incomplete logbooks, an undocumented repair, a damaged thrust reverser history, overdue ADS-B paperwork, engine cycle inconsistency, or an unresolved service difficulty, the intermediary may suddenly discover that the end buyer expects a deliverable that the seller is not contractually required to provide. This is how a spread becomes a lawsuit. The third failure point is records access and maintenance truth. In large turbine aircraft, the records are the asset's legal memory and their economic passport. If the intermediary does not control or have access to these records, it does not have an enforceable right to provide copies or does not understand what records actually show. It may unintentionally make representations that are false or at least incomplete. This risk is not theoretical. It is exactly why sophisticated buyers insist on direct records review, maintenance tracking confirmation, program status confirmation, and clear discrepancy resolution provisions. The fourth failure point is escrow architecture. In a clean two-party deal, escrow is already essential. In a back-to-back deal, escrow becomes the choreographer of the entire transaction. Who receives funds first? The first bill of sale, when is it released? What happens if the seller performs but the buyer does not? What happens if the buyer is ready, but the first seller cannot satisfy title conditions? Can escrow use the same incoming funds for both legs of the transaction? And under what written instructions? These are not clerical questions. They determine whether one failed step creates a domino effect across both closings. This is why reputable escrow providers even market specialized handling for back-to-back closings. The structure is common enough that the service ecosystem recognizes it, but it does not mean that it's simple. It means the failure modes are well known. The fifth failure point is regulatory and diligence overlay. AIN's due diligence discussion, republished by the National Aircraft Finance Association, points directly to the modern concern. Back-to-back deals require more scrutiny because fraud, cybercrime, money laundering, and bad actor risk can compound when you introduce extra parties. In a large turbine transaction, that means enhanced diligence on identity, sanction screening, source of funds, beneficial ownership, and the real commercial purpose of the chain. The intermediary may view itself as a market maker, a lender, insurer, export control specialist, or law enforcement may view the same intermediary as a diligence variable. There is also a practical tax and registration overlay. The intermediary short-term ownership may matter for state tax characterization, dealer exemptions, import status, and where and how closing occurs. A structure that works beautifully on a commission spreadsheet can fail badly if no one has thought through whether the intermediary is genuinely taking title, risk, and tax consequences, or is merely papering a pass-through. The sixth failure point, and one which should be obvious but often isn't, is reputation and disclosure. In a sophisticated market, secrecy about price is one thing. Secrecy about role is another. A seller may tolerate an intermediary's margin and still insist on transparency about who is actually buying. A buyer may tolerate an undisclosed spread less readily than people assume, particularly if the buyer later learns that the intermediary lacked control over the first leg, overstated exclusivity, or restricted direct contact for reasons that had more to do with preserving the spread than preserving the transaction. So, what is the practical strategy? Well, to a certain extent, mirror the rights. And that's to a certain extent. If the second agreement promises something, make sure the first agreement allows it. Control the records. Align the title package. Use escrow instructions written for a chained closing, not adapted from a simple one. Confirm exactly who is bearing pre-closing casualty risk, inspection risk, and tax risk in each leg, and force every party to answer the same question in the same words. What must happen before the aircraft can be released, paid for, and registered? In short, most back-to-back aircraft disputes do not arise because the idea is clever. They arise because one party sold certainty before securing control. I'd like you to remember this and take this away. The real danger in a large turbine back-to-back transaction is not the intermediary's profit. It is the intermediary's temptation to promise downstream performance that upstream paper does not support. Litigation examples and the playbook for structuring back-to-back deals defensively. Finally, let's discuss what the public record teaches us. Because aircraft lawyers should never pretend these risks are theoretical. The first example is Brindley Holdings, Inc. versus RSH Aviation, Inc., a federal case out of Illinois. The public record reflects a fight between two aircraft intermediaries, each trying to control a deal in order to buy an aircraft and resell it in a back-to-back structure. You do not need to know or be aware of every procedural detail to see the lesson. The court record captures the commercial reality that in aircraft markets, especially when inventory is scarce, multiple intermediaries may try to position themselves between the seller and buyer at the same time. This creates obvious pressure around exclusivity, confidentiality, interference allegations, and who actually has the right to control the transaction. The memorable lesson is this. In back-to-back aircraft deals, the first battle is not often over the aircraft, it is often over the lane. The second example is Zuma Seguros CA versus WorldJet of Delaware Inc. in the Southern District of Florida. There, the public records reflect allegations that the defendant wrongfully denied access to maintenance and logbooks and fraudulently induced the purchaser when it allegedly lacked ownership of the aircraft. Whatever one thinks about the merits of the parties' positions, the case is a powerful illustration of the exact risks that back-to-back and intermediate transactions create. Uncertainty over ownership, uncertainty over assignment, and restricted access to the records that define the aircraft's condition and value. In large turbine work, that combination is combustible. A third example is Jet Experts LLC versus Asia Pacific Aviation Limited, involving a Bombardier Challenger 300. That case was not framed as a classic broker back-to-back dispute, but it is highly instructive because the federal court ordered specific performance and directed transfer of legal title, possession, and control of the aircraft after finding the seller had unjustifiably terminated the deal. The lesson for back-to-back transactions is stark. If a party in the first leg thinks it can walk away because a better downstream opportunity appears, a court may not agree. In a moving market, a paper right to flip value can become a court order to perform. And the deepest legal warning remains Philco Aviation versus Shackett from the Supreme Court of the United States. Philco was not about a modern large cabin broker chain, but it remains foundational because the court made clear that undocumented or unrecorded transfers cannot be relied upon against innocent third parties. That principle matters profoundly in back-to-back closings. The market may run on calls, emails, and urgency. Title priority still runs on documentation and recordation. And here's something I would like you to keep in mind and remember. Aircraft deals may begin in conversation, but they are won or lost in the chain of paper. So, how do you structure a defensible back-to-back transaction for a large turbine aircraft? First, decide whether the intermediary is truly buying and reselling or merely facilitating. If it is facilitating, document honesty as a brokerage or agency agreement. Do not simulate ownership if the intermediary is not actually taking the rights and burdens of ownership. Second, if the intermediary is truly in the chain, mirror carefully, with some exceptions, the rights and deadlines across both purchase agreements. Inspection access, records access, discrepancy standards, delivery conditions, casualty allocation, deposit rules, and closing mechanics should all be intentionally considered and aligned as appropriate, not casually copied. Third, centralize the closing architecture. Use one escrow agent that can address both legs: title releases, wire timing, lien payoff, and what happens if one leg performs and the other fails. Large turbine deals are not forgiving of improvisation at 4:45 p.m. on closing day. Fourth, run enhanced diligence on all parties and on all funds. In today's market, that means knowing who the intermediary really is, who owns the buyer, whether any sanctions or export control issues exist, and whether commercial explanation for the chain makes sense. A structure that cannot survive a basic "why is this deal built this way" conversation is not ready to close. Fifth, be disciplined about disclosures. Pricing can remain private if the parties choose. But the role of the intermediary, the source of deliverables, and any limits on records access or authority should not be disguised. Sophisticated parties can easily price around known constraints. They litigate about concealed ones. Sixth, remember the large turbine aircraft overlay. Confirm maintenance program status, engine and APU enrollment, life-limited part status, damage and repair history, STC status, equipment conformity, operational documents, and any owner trust, non-citizen financing, or international registry implications that could affect the chain. On a large turbine aircraft, incomplete diligence is often just deferred litigation. So, where do these transactions most often go wrong? They go wrong at the seams between seller and intermediary, and between intermediary and buyer, between records access and contract promises, between title theory and registration reality, and between urgency and proof. In short, back-to-back transactions are common because they solve real market problems in business aviation. But they become memorable for the wrong reasons when an intermediary tries to occupy the economic middle without controlling the legal middle. I would like you to remember this and take this away. The safest back-to-back aircraft transaction is the one in which every party can explain in one sentence who owns what, who can promise what, and what paper proves it. Thank you for your interest in this topic. This information is provided for informational purposes only and is not to be construed as legal advice. Questions are welcome, and please direct those questions to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.